You're listening to Soundside. I'm Libby Denkman. On May 2nd, Governor Bob Ferguson signed into law a new requirement that clergy of all faiths become mandatory reporters of child abuse, a move that's especially controversial for the Catholic Church. In a statement criticizing the new law, Seattle's Archbishop Paul Etienne said it violates the seal of confession, the private conversation between a Catholic priest and someone confessing their sins. Until now, admitting to crimes in a confessional retained similar legal protections as attorney-client privilege. Archbishop Etienne said, quote, "All Catholics must know and be assured that their confessions remain sacred, secure, confidential, and protected by the law of the Church. And any priest who reports information received in confession will, quote, be excommunicated from the Church." Dr. Russell Powell is the Father John Topol Endowed Scholar for Catholic Thought and Justice at the Seattle University School of Law, and he joins us now for further analysis. Dr. Powell, thanks very much for being here.
It's a pleasure to be here, Libby.
So let's just lay some groundwork for somebody outside of the church to sort of understand, how is the confessional supposed to work?
So, like communion, confession is a sacrament of the church, one of the seven sacraments, and it is governed in the Catholic Church by its own set of laws, canon law, and the canons governing how priests are to operate in the context of that sacrament require them to keep absolute confidentiality, with the punishment being excommunication if they do reveal anything.
And how has secular law traditionally treated this requirement from the church?
So in the American context, the first place that it arises is in a New York case in 1813 called the People v. Phillips, which was actually the first case in which a U.S. court interpreted the First Amendment free exercise of religion clause. And it specifically addressed clergy privilege in that context and found that there was such a privilege. There's a long tradition of it. Now, there are distinctions, right? In the vast majority of states, I think 29 states, religious workers, clergy, are mandatory reporters for purposes of things like child abuse. So that's one category, but priests function in all kinds of different categories. They may be advising, they may be operating as a manager, they can observe folks in their parish as they're saying mass. The context of the confessional is very, very specific in that specific one-on-one sacrament. And so the church historically has had no problems with the mandatory reporting statutes, which a majority of states have. A handful of states have accepted the privilege. That is, they do not acknowledge the privilege in the case of, in particular, child abuse and child sexual abuse. Those statutes have not been tested. So it's true that they are out there, but that does not necessarily mean that if they were tested now, they're going to survive scrutiny. And there are a few cases that have tested this. Most of them are 10 years old or older. So I do think the context today in terms of constitutional law could be different if that were tested with the current Supreme Court.
And just so people know, a mandatory reporter in Washington state, they are legally required to report suspected child abuse to either law enforcement or the Department of Children, Youth, and Families. And generally, this new law is adding clergy to a group that includes nurses, social service counselors, psychologists, many people that, in the course of their work might come across potential abuse that they are required to report. You talked about cases where this was challenged. There was an interesting one in Louisiana in 2014. I think you told our producer about this. This was something that went all the way to the Louisiana Supreme Court. Tell us more about what happened.
So it's a thorny case. It's a really unfortunate case. So the facts arose in 2008, 2009, where a young girl who, at least in the testimony at trial, was giving information about her sexual abuse to her priest. From the priest's point of view, that was in the context of the sacrament of confession. And then later, she came forward and wanted to bring suit against her abuser. and wanted to bring in the priest as a witness. But because of the privilege, the diocese and the priest maintained that it would be inappropriate for him to testify. So the case ultimately found that the privilege was held, at least in the context of Louisiana law, by the priest and not by the penitent, not by the young girl in that case. And so he could not be required to testify. There were constitutional claims. It was actually appealed to the Supreme Court. The Supreme Court refused to hear the case, so it went back to the Louisiana State Supreme Court. The problem, I think, in Louisiana was that the court was getting enmeshed in these theological questions, which put it in a very awkward position, which is one of the reasons why we have the First Amendment provisions both for non-establishment and for free exercise, because we're really uncomfortable with the state being in that role, whether it's courts or Congress.
What are the First Amendment issues that you foresee if there is a challenge to Washington's law, which, as we heard from the Archbishop Paul Etienne, the church is highly critical of the law. It's, I think, a fair assumption that there will be a challenge at some point. What are the First Amendment issues that you foresee coming up?
There are actually both First Amendment speech issues and First Amendment free exercise issues. So from the point of view of the diocese and from individual priests, there's the free exercise claim that I have an obligation under my faith and as a priest, if for someone who's a priest, to abide by the canon law requirement and to protect confessors from having anything divulged that could harm them. And that I'm not in a position to even determine that. I just cannot divulge anything. Now, in other contexts, if I'm a priest and I become aware of something problematic and I'm a mandatory reporter, if it's not in the context of the confessional, I still have an obligation to report up. And that's been a major change. I think it's been positive in terms of this legislation since the early sort of sexual abuse revelations in the late 90s and early 2000s. But in terms of the confessional, there's still this problem. So there's the free exercise problem, but there's also a compelled speech problem. So you may be aware of the 303 creative case that arose in Colorado, where a publisher of websites who was designing websites for weddings was afraid that she would be sued or sanctioned by the state if she didn't provide those services to gay couples under the non-discrimination statute enforced in Colorado at the time. And so she preemptively brought suit. No one had come to her, but she preemptively brought suit and won at the Supreme Court because she construed that statute in Colorado as compelling her speech, compelling her to provide these services, which constitutes speech. Similarly, mandatory reporting is a form of compelled speech. You're forcing someone to speak and in such a way that it violates a sacred commitment they have to their faith. So I think both of those arguments are going to be made. And I think given the most recent cases, it's possible that could be successful with the Supreme Court, which I think is why California decided not to pass such a law 6 years ago.
On the other hand, Washington State, and I know I've seen Noel Frame, who is a prime sponsor of this bill, and others say this is a compelling interest of the state to stop child abuse and to create a situation where anybody who hears about it, who's in a position of authority or influence, should report this. What's your perspective on the state's argument that this is just something that is overriding the free exercise clause of the First Amendment because it is such a compelling interest of the state?
So there are a couple of different issues. The first is, what is the standard that the court's going to have to use to determine whether government intervention is appropriate? So I think that the sponsors of the bill are relying on a Supreme Court precedent called Employment Division v. Smith, which was a case involving the use of peyote in a sacramental way, where Oregon had a statute preventing it and treating it as a drug enforcement issue. And in that case, the Supreme Court, in an opinion by Justice Scalia, one of the more famously conservative justices, found that it was appropriate as a matter of rational basis for the state to make regulations, so long as they are neutral, generally applicable laws. As this was, it would apply to any sort of drug enforcement action if it were for purposes of public health, safety, and morals. So I think that's what the sponsors are relying on. And historically, that might have been a strong argument 10, 15 years ago, but the court has over time eroded the strength of the Smith standard. And in the same way that they have overturned other major standards, the Roe decision in Dobbs or the Lemon test in the Kennedy case, which is also a local case here in Washington, I think it is very likely that the Supreme Court, if not this term, in a case that could arise out of this from the statute, could overturn the Smith decision explicitly. If the standard is strict scrutiny, then the government has to show a compelling interest. Is protecting children from sexual harm a compelling interest? Absolutely. I don't think that's in dispute at all. But the other thing that the government then has to do is they have to narrowly tailor the remedy in the statute. And one argument that's been raised in other jurisdictions, including California at the time, was that by not having some kind of exception for at least the narrow confessional privilege would not be narrowly tailored enough to survive strict scrutiny.
I think for somebody who isn't Catholic and who doesn't understand how important confession is in the Catholic faith, to hear that a priest may hear in confession that there was abuse happening, or that let's separate it from child abuse and just talk about, violence. Somebody's bought a gun and they want to do violence, or they're having dark thoughts, that priest has to keep that in confidence and not talk about it or report it or, intervene with the proper authorities. That's hard to hear for a lot of people. I mean, can you kind of translate the reason for that for the average person?
It would create two problems in the Catholic context. It would create a problem for priests. I mean, it's, as you identify, this is already a horrible problem for someone who is in a particular calling and profession because they want to serve people, to hear horrible things happening or about to happen. But the church takes the position that the role of sort of intermediary role to minister reconciliation and forgiveness is so paramount that it has to trump any other concern. Now, outside of confessional, if you're aware of those things, absolutely, you have a requirement to report, right? So if you observed something in the parish hall, if someone just told you something in a non-confessional context, and the sacrament is very specific. Now, one area where I think the sponsors of the bill have serious concerns is a number of traditions that don't really have this extremely strong standard for confidentiality in a sacramental context have adopted an argument that certain communication is essentially the same as the sort of confidentiality and confession in the Catholic context. So I think Christian Scientists historically did this a little bit. I know Scientology definitely does it. I understand that in some of the cases, the Jehovah's Witnesses have raised that certain communications rise to that level of necessity for protection. So I'm not an expert in those traditions. I don't know that they're the same or similar, but I know that the concern of people concerned about children's welfare is that it then becomes a pretext for avoiding liability. And that's a legitimate concern.
So where does the likely challenge to this law come up, Professor? I mean, we are looking at the Department of Justice eyeballing this case. Harmeet Dillon, the Assistant Attorney General, has already talked about that she's looking at this. What are you watching for as this kind of plays out, as the Department of Justice and potentially plaintiffs in Washington state are looking at what to do about this law?
I can't think of a time or a case where the Department of Justice has taken an advocacy role for a particular denomination in this way. That strikes me as unusual. I don't know how they would move forward in terms of enforcement. I suppose they could bring a suit. I don't know exactly what their standing would be. I do think the more likely outcome would be that one of the archdioceses would bring a claim, either preemptively, which I think is possible given current case law, or if a case really arises. Although very few of these cases in the context of confessional privileges have arisen. There have been a handful that I'm aware of in the last 10 to 15 years. So it's likely that the diocese would bring the claim. And I don't know what role, other than maybe an investigatory role, the DOJ would play.
And if this does make its way to the Supreme Court, how do you anticipate those arguments going and the justices, the current makeup of the court, weighing in on this?
So if Smith is still good law, the Smith case that I mentioned earlier, then they're going to have to address that. And they could take an opportunity such as this kind of case or controversy to overturn Smith explicitly. I also think there's a possibility that they will have already overturned it. There are a couple of significant religion cases up before the court right now that'll come out in the next month or two. It is possible that one of those cases could explicitly overturn Smith. A number of the conservative justices have, even in their opinions, anticipated that they want to overturn Smith. So I think that is very, very likely in the next few years. It's just a matter of which case they choose to do it in. But then I think there's a good possibility they find in favor of clergy on the basis of First Amendment free speech because of the compelled speech issue I mentioned and free exercise.
You brought up the church's history with child abuse, and I think that supporters of this law will say the church can't be trusted to police its own house when it comes to child abuse, and they've shown that they have a checkered past in how they've dealt with abuse cases. What do you think about the way that the church specifically is having to navigate this? I know you're a law professor, not a PR professor, but what do you think about, whether the church is going to want to have this high-profile legal battle over disclosure of sexual abuse?
I actually, just before this, read a very detailed article looking at the history of sexual abuse and sexual abuse cases in Louisiana, which had a very storied history through the 60s through the 80s. And it's horrific. We are not immune from that here. There have been lots of horrible cases in the Northwest as well. I suppose it's possible that the Archdiocese or the Diocese of Spokane might choose not to move forward with any sort of case and just let the law sit as it's sitting in about 7 other states where there is no confessional privilege, but just not anticipating that there will be any cases that arise. I mean, one good thing about this law is it does make these folks clear mandatory reporters, and I don't think the church objects to that. I think the Catholic Church just is objecting to the specific requirement that if it were to break the canon law requirement of confidentiality from confession, then that's a problem. But I also, having read a number of the cases in Louisiana, most of those cases didn't come to light because of confession. It was supervisors knowing what the people under them were doing. It was bishops knowing what priests were doing. So the specific confessional privilege, I think, is really narrow. And maybe the diocese will presume that it's going to be so narrow it's not likely to arise, and then maybe only challenge it if it were to arise in a specific case. But the way cases are being raised these days, a lot of cases challenging statutes on First Amendment grounds, whether it's religion or speech, are being brought preemptively. So I don't know what any of the parties are going to do at this point.
Is there anything we didn't talk about that you think people should know about this issue or this specific law in the context of your area of study?
That it's not particularly unique. Most states have some kind of mandatory reporting for clergy explicitly. Another large chunk also have it for any person who's aware of any information related to child sexual abuse, for example. I think the goals are laudable. I think we all want to make sure that children are protected, but it does raise a thorny problem. I mean, it puts a priest potentially, if this were to arise, in a position where they would have to potentially risk going to prison, right? Because I think up to a year in prison is the punishment under this statute as a gross misdemeanor, or to be excommunicated from the church, which is sort of an existential choice.
Dr. Russell Powell is the Father John Topol Endowed Scholar for Catholic Thought and Justice at Seattle University School of Law. Thank you very much for walking us through this very thorny and complicated issue. Dr. Powell, I really appreciate your perspective and expertise here. Thank you for being on the show.
Happy to join.
You're listening to Soundside on KUOW. I wanted to add a comment from listener Bill, who wrote in when he heard we were covering this story. Bill says, as a Catholic, I have made Catholic confession, and the priest has always ordered me to do something in order to be absolved. I don't see why Archbishop Etienne cannot order diocesan priests who do the sacrament of confession to order the penitent to report the sexual abuse that they have confessed to a responsible party who would mandatorily report the abuser. I don't think that this would cause the priest to either violate the privacy of the sacrament of confession or to leave the abuse private. Thank you, Bill. Thanks, Bill. And you can also weigh in with an email to soundside@kuow.org or leave us a voicemail at 206-221-3213. 206-221-3213. Thanks for listening to Soundside. And hey, this show is only possible because listeners support us. If you are able to give right now, check out the show notes for a link to donate. And don't forget, you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m., Monday through Thursday, or anytime online at kuow.org.